And today we have another interesting topic to look at, like the Nigerian Police Force Established Act 2020 implications on human rights. That is the topic of discussion for today. And to discuss this, we have Olaita Eyowawi, consultant solicitor, Simeon Bethel Solicitors, London, United Kingdom. You're welcome, sir. We also have Mazi Afam Osigwe. He is a senior partner at Law Fort and former General Secretary, Nigerian Bar Association. You're welcome also. We also have Kunle Edun. He is a human rights activist, welfare secretary, Nigerian Bar Association, and senior partner, Trilex Partners, LP, Warri, Delta State, Nigeria. You're welcome.
Thank you very much.
Finally, on our list, we've got Sylvester Udemezue. He is legal practitioner and lecturer, Nigerian Law School.
Thank you very much. Without wasting time, Mr. Sylvester Udemezue, who is a lecturer at the Nigerian Law School, to speak on the subject.
Thank you very much, my ogas, Mazi Afamosigwe, Mr. Olaito, and Mr. Kunle Edu. I'm very happy to be here this evening to participate in this discussion. I hope you can hear me all.
Yes.
You can hear me here. So I'm happy to participate in this discussion. Because of want of time, I wouldn't like to go back to what has been discussed by my senior panelists. I would want to just raise one or two other issues in addition to the ones already discussed. I think I've pointed at this earlier, the provisions of section 32 of the Act, that because we're talking about how the Act has impacted on human rights. Now, if you look at section 32, section 66, sorry. So if you look at section 66 of that Act, which provides, if I may refer to that, the section actually says, there shall be assigned, section 66, subsection 3, section 66, subsection 3 of the Act, there shall be assigned to every police division at least one police officer who is qualified to practice as a legal practitioner in accordance with the Legal Practitioners Act, whose responsibility is to promote human rights compliance by officers of the division. Now, all my colleagues have spoken, each person harped so much on how poorly drafted and how very much the Act has gone into creating so many confusions. In fact, creating more problems than it has come to solve. Now, I will say two things about this particular provision. Number one is that it's a good provision because it has tried to, what it intended to do is to bring in a lawyer. A lawyer must be attached to every police station. And the duty of the lawyer is, or his responsibility is to take care of issues relating to human rights. In other words, his duty is to advise the police and ensure that every police station complies with aspects of provisions of human rights. In other words, everything that has to do with section chapter 4 of the Constitution. But the question now is, looking at this provision critically and reasonably, to what extent do we think that this policeman, this lawyer assigned to a police station will do this work? It is my opinion that this section, although an innovative one, would achieve very little. How? First and foremost, the lawyer you are posting to the police station is a policeman. So you are posting him there to go and monitor his colleagues. To what extent, just like Mr. Olaito pointed out, appointing a policeman, for example, to investigate a policeman, appointing a policeman to take care of complaints relating to a policeman. The commission or the body set up to look into issues of human rights violation and complaints against police officers. The body comprises wholly of police officers. To what extent do you think that the body will be able to decide that responsibility? So although I do not see that body, that complaints body, as a new body, because there had been X squad. The police X squad is a department in the police force, within the police force, that is in charge of all forms of complaints. So we used to have the complaints as section of the police force. So the question we're asking is, to what extent will this subsection achieve the objectives of the subsection? It is my opinion that this is just like Mazi Afamosigwe pointed out, is a very poorly drafted, not well thought out, because a policeman is being sent to a police station, although he's a lawyer, to go and monitor, to go and advise his colleagues. Today, we see issues of violation of human rights, even in the state CID. Remember that every OC legal is usually, he has his office just at the state CID, most of the commands. So the question is that if the OC legal and all the lawyers in the department, the legal department of the state CID, have not been able to check issues relating to violation of human rights, detention beyond 48 hours, abuse of human rights, issues relating to liberty, observance of all provisions of law relating to liberty of the suspect or the detainee. To what extent do we think that posting a lawyer or a policeman who is a lawyer to a police station would achieve this? Now, if the act had provided that a lawyer should be attached to a police station, that would have been better, okay? Because anybody that would be able to monitor and advise the police should be independent of the police. He shouldn't be under the control of the police, because if he posts anybody who is junior in rank, of course, you know, police is a military organization or a paramilitary organization. So when you post anybody who is a junior in rank, if the DPO, for example, is on the rank of SP or CSP, and you are posting an SP who is a lawyer to go and stay at the police station, the first thing he has is to be obedient to his masters. So he might not be able to do that job effectively. That's number one. Number two, posting only one person who is a legal practitioner to the police station is not sufficient to achieve the objectives of posting the person there. So I don't think that will do much towards achieving the objective of protection of the human rights of detainees or suspects at the police station. So I think there is need for an urgent amendment of that section to provide that station not be a police officer. I think it should be an independent body that is there to take care of issues of human rights, to advise the police, so that they will be able to, where they render the advice and the police do not listen, they will be able to make reports, appropriate reports, like to National Human Rights Commission about issues of violation that they have observed. If you place a police officer there, he wouldn't do things that might amount to indiscipline within the police force. And even if he says, okay, let me do things because this is in line with the Constitution, he might be subject to other aspects of victimization, being an employee of the police force. He might be seen as somebody who is trying to do IT care. That's, I too know. He's like trying to expose the police force to ridicule, to the general public. So that is why that provision that says that the person must be, the lawyer must be a police officer is not adequate. That is why my suggestion on that. Then second aspect, the second thing I want to say about that is that it shouldn't be only one lawyer that is posted to a police station. If we want issues of human rights to be properly monitored and followed up at the police station, there is need to post more than one lawyer to the police station. So the person must be independent, and then one person would not be enough, because so many cases are being dealt with at the police station at a time. Then going to section 38, subsection 1 of the Act. Section 38, I would like to say a word on section 38, because this had been reoccurring. This had been there in several other laws. The CPC has the same provision. The CPCL has that provision. The CPL has the provision. The ACJL has it. The ACJL of Lagos 2011 has it. The ACJA of 2015 has the same provision. Now, there is a question that arises when we look at section 38, subsection 1. A police officer may, without an order of court and without a warrant, arrest a suspect, A, whom he suspects on reasonable grounds. Whom he suspects on reasonable grounds of having committed an offense against a law in Nigeria or against the law of any other country. Now, the question is, how do we define whom he suspects upon reasonable grounds? what we're trying to say is that the policeman, of course, his reasons for arresting a suspect must not be subjective. Now, who will determine the reasonableness or the reasonable ground before the policeman can arrest? If you can arrest someone upon reasonable grounds of having committed some offense, how do we determine the reasonable ground? So that I suggest that, I submit that this has given the police the leeway to violate human rights, because this has made it possible for the policeman to tell you, oh, I suspected that he had committed an offense, even though, of course, if a person is found out later not to have committed any offense, the policeman will tell, okay, from the way he behaved, I suspected he had committed an offense. I had reasonable grounds to suspect that he had committed an offense. So this has made it possible, okay? It has given the police a wider power that might maybe be liable to be abused by the police. So I think that provision needs to be amended to define specifically the conditions or the terms upon which a policeman may arrest without a court order and without a warrant. Another one is the paragraph B of section 38 subsection 1 that talks about obstructing a police officer. It talks about the police officer being able to arrest without a court order and without a warrant anyone who obstructs a police officer while in the execution of his duty, or who has escaped or attempts to escape from lawful custody. Now, while attempt to escape and who has escaped, these are very clear. The question now that arises is, what is the meaning of the expression or the word obstruction? This has generated a lot of debate in so many platforms, okay? The question now is, how do we define obstruction? I've searched through the police, Nigerian Police Force Establishment Act 2020. I cannot see any section, even the interpretation section, that try to express or define or interpret the meaning of the term obstruction. That means that the policeman now might decide of his own volition that, oh, this person is obstructing the performance of my duty, and he will take that person into custody by way of arrest. I think that the Police Act 2020 needs to make provisions as to what it means by obstructing. We need to now begin to go through other laws, including foreign and the law dictionaries and foreign legislation, to find out the meaning of the word obstruction. So there is need. If you say you can arrest someone for obstruction, there is need to provide for what is called obstruction. Because my own research on what might amount to obstruction actually gives a very wide interpretation, which is liable to be abused. For example, obstruction does not necessarily mean somebody who tried to stop the police. For example, if a policeman invites you to the police station upon maybe during the time of investigation of a criminal offense, an alleged criminal offense, and you refuse to come, he might interpret that to mean an obstruction. Okay, so anybody who fights the police officer or resists an arrest might be interpreted to have obstructed the police officer in the lawful performance of his duty. So I think there is need to delimit the scope of the word or the term obstruction, so that it will be very clear what they meant by that. Then I would like to point out, talk on the provisions of section 35 of the Constitution. Of course, the Police Act, like my big brother, Mr. Kunle Edu, has pointed out that the Police Act has made it optional for a suspect to be with a lawyer at the time his statement is being taken at the police station. With due respect, sir, I would like to suggest that I think why the Police Act actually limits itself, left it at that optional angle, is because this Constitution does not make it mandatory that the lawyer must be with a suspect at the police station. So if I may be permitted to point out the provisions of section 35, subsection 2. Section 35, subsection 2 of the Constitution of the Federal Republic of Nigeria, it says, any person who is arrested or detained shall have the right to remain silent or avoid answering any questions until after consultation with a legal practitioner or any other person of his own choice. So what the Constitution has done is to give you the right, okay, to choose not to talk or to remain silent until you have consulted a lawyer. The Constitution did not say that you must consult a lawyer before you talk. So I think that that provision in the Police Act that talks about, makes it optional to be with a lawyer when your statement is being taken. It's properly drafted. It might not be an aspect that we need to criticize, because if they have to make it mandatory, it will be in direct conflict with provisions of Section 35, Subsection 2 of the Constitution. Because Section 35, Subsection 2 does not say that when you are arrested or detained, you must have the service, they must call a lawyer. You may choose not to call a lawyer. It depends on you. It is your right. You may say, I don't want to say anything. But if you elect to say something, if you elect to make a statement in the absence of a lawyer, that does not amount to any violation of your fundamental human rights. So I think I approve of that provision that talks about, makes it optional, that you have to be with a lawyer before a statement is made. Although I would advocate in support of Kunle Edu that provision should be amended, but the amendment must come from the source. Because if you make it mandatory in the Police Act, that will be in direct conflict with the Constitution. The Constitution does not make it mandatory. It gives you a right. It is left for you to exercise your right or to choose not to exercise it. So if a suspect chooses to be with a lawyer or to consult a lawyer before making a statement, it is left for him. If he decides not to do that, nobody can force him to do that. And the fact that he was not with a lawyer when he made a statement does not amount to a violation of fundamental human rights, provided that the other provisions of laws relating to taking of his statement, including the judge's rules and other things, are observed. So I think I have to stop at this point. I don't know whether I have already exceeded my 10 minutes.